Virgin Media Ltd and NTL Trustees to Limited and others.
Yes, good morning, Mr. Allman.
Good morning, Madam. On reviewing the transcript, I saw one point where I may not have given my Lord Jackson a sufficiently precise answer, for which I apologise. On page 39, lines 19 to 25, we were discussing the 1995 Act, and in particular the definition of accrued rights in section 124, subsection 2 of the 1995 Act. And my Lord said, right, so far as definition is concerned, we have a definition which you have just taken us to in part 1. That was section 124. We have nothing in the general definitions at the end, and my learned friend very kindly indicated there was two or three definitions in paragraph 176. And we don't have anything directly concerned with this question of accrued rights in part 3. And I said, correct, my Lord. I should perhaps have clarified which part 3 my Lord was asking about. Part 3 of the 1995 Act introduced all of these changes to contracting out. And if I could take you to the supplemental bundle of authorities. Which is tab 58. Page 1265 of your bundle. You can see at the bottom, new certification requirements applying as from the principal appointed day. And above that in introductory, the principal appointed day for part 3. And sections 136 to the end of this tab include the key gateway provisions for the new contracting out regime, sections 9, 12A and 12B being inserted. And if one then turns back into the main authorities bundle, tab 3, which is the 1995 Act itself, to page 144, you have section 151 giving effect to Schedule 5's amendments. They start from page 145, is the beginning of Schedule 5. The relevant ones for our purpose begin at page 148 in the bundle, a whole section devoted to the Pension Schemes Act 1993, including, at page 151, the introduction of the new section 37 as a critical part of the process. My answer to my Lord Jackson was confirming that part 3 of the 1995 Act did not directly address the meaning of accrued rights within the contracting out provisions that the 1995 Act introduced. But I should perhaps have emphasised that that was because there was already the definition of accrued rights for contracting out purposes generally within part 3 of the 1993 Act at section 20 subsection 6. I just wanted to be precise as to which part 3 we were both talking about. And if I could just show you, while we've got the authorities bundle, tab 2B, page 93. You have that defined term, bottom of the page. In the provisions mentioned in subsection 3, accrued rights in relation to an earner means the rights conferring prospective entitlement under the scheme in question to the pensions to be provided for the earner. And when you go up to subsection 3, it includes any provision of this part. So for the entirety of the contracting out regime, there was this defined term already within the 1993 Act, which is why the 95 Act didn't need to make any addition in that regard. And if we turn to page, or tab 53,
Sorry, if you just give me a moment. Yes, I'm sorry, tab 53.
tab 53, please. Page 1236. That was why the Good Report, in its glossary, specifically referred to accrued rights being specifically defined for contracting out purposes, as Lady Justice Asplin helpfully pointed out. And I referred to the fact that at paragraph 40A of our skeleton argument, we had referenced the provision of the Social Security Pensions Act 1975, from which that definition in section 20, subsection 6 of the 1993 Act was derived.
You referred us to section 20, subsection 6 yesterday. I didn't raise it then, but I'm still puzzled about it. The entirety of section 20 is a regulation making power. But the regulation making power is in subsection 1, it is dealing with transfer payments in respect of accrued rights to GMP. And by the time we get to 1997, as you pointed out yesterday, all GMPs are necessarily past service. And indeed, even before 1997, when it's talking about a transfer payment, necessarily what you make a transfer payment in respect of is past service rights, not future service rights. And I'm just puzzled whether the definition in 20, subsection 6, extends any further than explaining what accrued rights are in the context of a transfer of accrued rights to GMP. Because it seems an odd place to put it if it's meant to be a general definition for the entirety of Part 3.
Well, my lord, the literal terms of the subsection say that accrued rights in relation means the prospective entitlement under the scheme in question, and it says in the provisions mentioned in subsection 3, which are any provision of this part. So it may be that it was thought convenient to give that defined term in the context of section 20 because that relates to transfers of accrued rights. But I don't think it can be doubted with respect that the definition is applicable to the entirety of chapter 3 and all contracting out.
But in the context of a transfer, because subsection 6 refers back to subsection 3. Subsection 3, again, it's all part of a regulation making power, but it says that regulations can say things where there has been a transfer to which regulations under subsection 1 apply. Regulations under subsection 1, as I've said, limited to transfer payments in respect to GMPs.
Well, it's certainly right that the regulation making power at 3 relates to transfers, I accept. But in terms of where the definition applies to, section 6 makes clear that it is simply saying that this definition applies in the provisions mentioned in subsection 3, which is any provision of this part. And I persist in suggesting that.
Okay. Well, I've read.
Yeah.
I have your answer. Thank you.
And without wanting to go back into the detail of it, just by way of recap, I had shown you Bradbury, showing that for legislative purposes, it has been held that you had no accrued right, even to such increase in past service accrual, as may flow from future increases in salary. Lady Justice Gloucester held that such an increase which a member may acquire was a future right to a pension. She wasn't characterising it as a present right for the purposes of the 1995 Act. And we say that if so, it must surely be a priori that future service accrual.
You said for the purposes of the 1995 Act. I thought BBC and Bradbury was a case on the construction of a factor of an amendment.
No, my lord, it was in relation to section 91 of the 1995 Act. And my submission was that it must surely be a priori that future service accrual is even less susceptible of being characterised as a right. It is again only something that a member may acquire in the future. It is not even linked to anything already earned in the past. The legislation doesn't characterise it as a right any more than you could say that you have a present right to next year's salary. You haven't earned it. But where we left off yesterday, I was making submissions on the structure of Regulation 42.
Well, I suppose, if we're talking about rights, I appreciate you're leading with the definition, but there's a wider concept of rights at play in this case, which is to do with the right not to have your pension terms changed, other than by proper process.
There is a right, I'll rephrase that. There is an inhibition to making amendments. There is a restriction placed on the power of employers and trustees to make amendments to the rules of a scheme. Now, you may, in the future, through future service, accrue rights. That will be in the future. My Lord Justice Nugee referred yesterday to, it makes perfect sense to say that you would have a right to continue to accrue. But as soon as you interpose the words "continue to," you have revealed the fact that the past participle accrued is not yet applicable, not yet there. You may continue to accrue it. You may have a right to remain in employment, but you have not accrued as a past participle the pension pay that would flow from that future service.
Yes, that is a different point. But your point, and you addressed us on this yesterday, was that the very word rights, by itself, without any addition of the word accrued, is confined to things you already own. And I was just querying that. Now, I entirely accept that you have a different and maybe much stronger point on accrued rights, where the answer that's given by Mr. Short, I anticipate, is well, I accept that accrued rights means what you've already earned, but it's not looking at the date of amendment, it's looking at the date when you come to take your pension, which is a different point. But I don't think he disputes that future service rights have not yet been accrued. I think he says, but we're not talking about this date. It's not a temporal question. It's
He says
classification. What he calls qualitative.
Yeah.
Yes.
I accept that, but the point I have sought to tease out from both case law, like Ms. Reed QC's dicta in Wedgwood and Salt, or the holding in Bradbury, or the other bits of legislation like Section 124.2. is that the legislation consistently uses these defined terms of accrued right or rights or entitlements to payment of pension to describe present rights. Even when it talks about being prospectively entitled to pension, it means you've earned it now, it's an accrued right, and you will receive it in the future. There are no places in the legislation where the drafters, in my submission, talk about rights or accrued rights or rights to the payment of pensions in relation to things that you may earn in the future by future years of service. And, for example, my lord, you can say that, well, in section 124, subsection 2 of the 1995 Act, it says the rights of a person are those at any time, are those that exist at that time. But in my submission, that merely makes explicit what was already implicit in the definition in section 20, subsection 6 of the 1993 Act. And I showed you in the 1993 Act various provisions where, without any qualification, anchoring the words accrued rights to a particular point in time, it should be self-evident that it's talking about the accrued rights at the point of time that the legislative provision falls to be applied. And as I also said yesterday, but to complete the conversation, my lord, you say that my learned friend will refer to it being qualitative. That doesn't explain why you need to have a distinction between two types of past service rights, rather than just referring to pension benefits. It's a particularly strange bit of drafting to go to the bother of framing it entirely in past service rights, which you say my learned friend may accept. So they use specific terms which relate to past service rights, two different sorts which they differentiate and draw a distinction between, which would be totally meaningless and unnecessary if all you needed to capture was pension benefits, as opposed to lump sum benefits.
Right.
So,
where have we got to on your agenda?
I was making submissions on the structure of Regulation 42.
Yes.
And I had said that GMPs and protected rights were terms defined by the primary legislation. And I think I should show you those provisions, the definitions, just so that I make that good. So could I ask you to turn to tab 2B. Page 133, where you have the general interpretation provisions for the 1993 Act. We're in the 1993 Act. And then over the page, you have in the middle of the page, guaranteed minimum pension being defined has the meaning given in section 8.2, which I showed you. And if you turn over a page further, a third of the way down the page, you have protected rights. Has the meaning given in section 10, which I showed you. Just in passing, I noted that rights is mentioned in the middle of the page. It's in relation to accrued rights within the meaning of section 73, 138.
Where are you reading from? Where are you reading from?
Halfway down that page, there's a definition of rights.
Yeah.
And I just identified that in fairness to acknowledge that section 73, 136 and 179 are not within chapter 3, but nonetheless it shows continued consistent use of rights and accrued rights, referring to that which you already have earned. But I accept, of course, that they are not within chapter 3. Having shown you those definitions in section 181. Can we just go back briefly to page 85 of the same tab, just to refresh our memories of the definition of protected rights. And I had explained that they were rights to money purchase benefits, and that under subsection 2, the rules could provide for the only bit of your money purchase accrued past service benefits were those relating to the minimum payments rebate. So they're past service rights. And I had mentioned but not taken you to section 27, which is on page 95. Which requires that where the rules of the scheme make such provision as is mentioned in section 10, subsection 2 or 3, so to confine your past service protected rights to just part of your money purchase accrual, they must also make provision for the identification of the protected rights. So just to reinforce the fact that these are past service rights that must be identifiable as such having been accrued. They are not like future rights that may accrue of infinite and indefinite extent. Now, where I left off was to say that each paragraph of Regulation 42, and that's on page 222 of tab 6. That each paragraph of Regulation 42 was conditioned by its stem, restricted. In relation to GMPs, in paragraph 2, capital B, in relation to protected rights, that's 2, capital A, and in relation to 9(2)B rights, paragraph 2. And so the conditions which the alterations must respect, which you see as the last sub-paragraph of each of those main paragraphs, it's still in relation to a past service rights. And I had referred you to the fact that there are restrictions on ability to commute benefits as an illustration of the sort of condition that would apply to past service rights. And I had shown you back in tab 2A that in section 12A, which is page 87, sorry, 86, sorry, I'm not 12A, it should be 9, section 9, 9(2)B on page 84, that there were 5 conditions being prescribed, and it was the coda that made reference to the rule, how the rules of the scheme were framed. It is such that the rules of the scheme are framed so as to comply with the relevant requirements. As I say, restrictions on commuting benefits were in regulations 19 to 20. And I had suggested that the significance of that is that the drafter had had to coin a new definition for rights, past service rights accrued pursuant to contracting out under section 9(2)B, and had done so using the words accrued rights, rights to payment, which were past service restrictions which didn't need to be repeated. But what I say is the significance of the adjacent provisions of paragraphs 2 capital A and 2 capital B, and also paragraph 3 concerning schemes which have ceased to be contracted out, is that they are consistent structurally with the fact that paragraph 2 is likewise exclusively concerned to prevent alterations affecting past service rights. For example, there would be no good reason for Regulation 42 protecting only past service rights in money purchase schemes contracted out after April 1997, but then extending protection to future accrual in salary-related schemes contracted out after April 1997.
Can I just be sure I've understood what you say about protected rights? The 42.2a paragraph. This, as you pointed out, little a of that has a restriction on adversely affecting any entitlement or accrued rights of any member of the scheme acquired before the alteration takes effect. So little a is 2a on page 222 is clearly confined to past service rights. But I thought your submission was the definition of protected rights, which is in section 10 of the Act, which are rights to money purchase benefits under the scheme, was itself confined to past service accrued rights. That is your submission.
That is my submission.
So what are the words doing acquired before the alteration takes effect? They're just surplusage.
They are surplusage. The drafter has put them in to be absolutely clear, if you like, within the four corners of this set of regulations, that this is only concerned with past service rights. And the reason that that has been added is because the fact that they're only past service rights is something you would otherwise have to go back to the primary legislation and rummage for.
Save you looking up.
Save you looking up.
Now, what I'm interested in is what is the scope of little b? Because my understanding of your submission is because this is all in relation to protected rights. Protected rights is itself limited to past service rights. Little b is itself confined to alterations which affect past service rights. It says nothing about the shape of the scheme going forward. Is that right? Is that your submission? But when one looks at what the conditions of section 9.3 are, we have the conditions of section 9.3 on page 84. Taken in the right version. An OPS satisfies this subsection only if the requirements imposed by or by virtue of sections 26 or 32 are satisfied. So there's a set of sections, 26 to 32, which tell you what you need to do in order to be a contracted out money purchase scheme. And if you look at them, some of them, let's take, for example, 27. The value, 27.2, the value of protected rights mentioned in 10.2 or 10.3 must be calculated in a manner no less favourable than that in which the value of any other rights of the member to money purchase benefits under the scheme are calculated. Now that's one of the requirements imposed by virtue of subsections 26 to 32. Is it your submission that you wouldn't be in breach of 42.2ab if you had an amendment which says, as far as past service rights are concerned, they have to be, money purchase benefits have to be calculated in the same way as other benefits under the scheme, but for the future, you will only get 90% of the value of your minimum payments attributable to your money purchase benefits. Would that not fall within 42.2ab?
In my submission, no, Michael.
No, because it says nothing about the future. So in your submission, you could effectively put in an amendment which made the scheme non-compliant with what's required to be a money purchase scheme, continue to pay reduced national insurance contributions and take away all the protections for members without any input from the actuary under 42, Regulation 42. That's what your submission comes to.
That is my submission, but if you look further on in section 9.3, you've got the requirements imposed by versions of sections 26 to 32, many of which would make complete sense in relation to past service rights. So a requirement that you can continue to identify them as a defined component of the past service benefit. That makes complete sense in relation to a past service right. If you read on to page 85, the top of the page, you've got these conditions that have here, and the rules of the scheme applying to protected rights are framed so as to comply with the relevant requirements. So,
but you say protected rights means past service rights, so it's not a requirement in your submission that the rules of the scheme say anything about the rights you're going to accrue in the future.
not in the future, I agree, my lord, but what it does do is say that the rules have to protect your accrued rights. So any rules applying to protected rights, like the requirement that the rules provide for them to be identified, is preserved for the part, is preserved in relation to past service benefits.
Well, I have to say, I know that you're going to come to this in the last section of your...
You're going to ask me about purpose and...
Yes, but I don't understand the policy. But that is, you have got a separate section dealing with that.
Yes,
but at the moment, I'm just trying to understand that I have correctly identified what you say as a matter of construction. This means you say it says nothing. 42.2a says nothing about the compliance of the scheme going forward with any statutory requirements. It's entirely concerned with the protection of the rights up to the date of the meeting.
My lord, yes.
Thank you. That's what I wanted to be sure about.
The contributions agency is supervising future behaviour. You can have your...
Yes, are we coming now to section 5? I mean, I'm just keeping some eye on the time.
Yes.
And it seems to me that that's a very important part of
yes.
This, so that you can explain to us how this is coherent if you're right about the
I will move very fastly past the respondent's notice point. The suggestion that the context otherwise requires. What that means in practice is explained by a strong line of authority summarised by Lord Justice Peter Gibson in Melville and the Inland Revenue Commissioners, which is tab 23. At paragraph 32 on page 550. And I'll leave you to read paragraph 32 to yourselves, if I may.
Yes. Well, that's very well put, but not very earth-shattering, is it?
Well,
it tells us what
it's not.
Otherwise requires. I mean, requires doesn't just mean it would be nice to do it some other way. It
where
means that you're driven to do it some other way.
Where effect can be given to the words, then you apply the definition. The context can't be said to require otherwise. It has to be compelled. Purpose and policy and guidance note 28.
Thank you.
To explain why we say our past service interpretation produces a coherent, meaningful, protective purpose, congruent with the rest of the mechanisms for the supervision of contracting out and accrued rights more generally, I have to explain that framework. The initial certification of a scheme as satisfying the statutory standard engaged a wider legislative and regulatory framework for the supervision of schemes. Once that happened, there was a series of mechanisms, as my learned friend rightly mentions in his Skeleton argument in a number of places. There was a series of mechanisms. And we gave an overview, paragraphs 21 to 22 of our Skeleton argument, to which we referred back at 48C.
Just a moment. Do you want to say something about what the overall purpose of these revisions concerned with the controls on the contracting act?
I want to describe the framework, my lord. Say these are the
I understand you're going to come to the bits of which this is, you would say, just one part. What's the overall purpose that is sought to be achieved here?
To protect rights which have received the contracting out rebate, been part of the contracting out reduction in national insurance contributions, from the ability otherwise to reduce such rights which had persisted under Section 67.
I'm sorry, can we try not to anchor it in the legislation? Just in the simplest possible terms, was Parliament concerned to essentially protect the pension rights in payment accrued and not accrued yet, so that they would be broadly equivalent under the new scheme as under the old? Or was it only concerned to protect past rights?
It was only concerned to protect past rights, to ensure that...
Right, so is your submission in relation to purpose that there was no legislative purpose to protect any rights from future service?
There was no legislative purpose to protect rights from future service through Regulation 42.
No, I'm not talking about Regulation 42. I'm talking about the whole thing. I'm talking about when Parliament approved contracting out, I would have presumed that it was concerned to protect all sorts of rights, past, present, future.
My lord, yes.
However, I'm using rights with a small r here, you appreciate. What people would have expected from their pension. What are you saying about that? Is that a correct assumption?
It is a correct assumption that it was intended to protect the contracting out regime, including for future accrual. But the framework, the whole framework.
Right. So the question then comes, are we to understand that it protected different elements in different ways, as I think you'll be telling us?
Yes.
And that, therefore, the Regulation 42 actuary step, we needn't be bothered that it didn't concern itself with rights that were yet to be accrued, as you would have it.
My lord, yes.
Right. So that's where you're going.
That's where I'm going.
All right. Thank you.
And you say future rights and measuring against the model scheme is protected by triennial valuation.
Yes, the future accrual is protected by, amongst other things, the triennial recertification.
Is the triennial recertification retrospective?
No, it is not in and of itself retrospective, but there is an obligation imposed on the actuary if the actuary learns of an amendment that has been made, to consider, and the words of the guidance are, it would have been possible to certify.
So I as a pensioner, or prospective pensioner, I don't have that particular, the actuary protection from the time that my past service ends, looking forwards. If I want the first 3 years, for example, of my future earnings, pensionable earnings, to be protected, I have to wait and see for 3 years whether the actuary is going to do something about it.
My lord, it's not a matter of waiting to see if the actuary is going to do something about it for a number of reasons. Firstly, there were obligations imposed, as we set out in the skeleton, to tell the actuary about changes that have been made or were being made. Secondly, once told, the actuary had an obligation to consider them under the guidance note. And the whole framework of the legislation is to move from an absolutist regime supervised by the Occupational Pensions Board to a regime in which the supervisor of contracting out was in the first instance the actuary. So to say you've got to wait until the actuary looks at it is, in our submission, unremarkable. That's the point of the legislation. There is an obligation to notify the contributions agency that falls on all concerned, but in particular the actuary, if a failure to meet the reference scheme test is not rectified. That again is the wording of the guidance note. So what it envisages is that the actuary will look at this. If he finds that the change happened in the past, he looks at whether it would have been possible to satisfy the reference scheme test, to give people an opportunity to put it right, and then only have the consequences of cancellation of a certificate with the liability to pay national insurance falling on the employer alone if things aren't rectified. But to make that good, I have to explain the framework. So we've explained in the scheme under section 47 subsection 9 and regulation 6 of the administration regulation, duties were imposed on the employer and the trustees to notify the actuary of material events affecting the contracting out requirements. And just by way of a gloss, subsections 10 to 11 made failure to comply with those duties would expose employer or trustee to civil penalties under section 10. That was backed up by the actuarial guidance note 29, which required the actuary to obtain an undertaking from the trustees to notify the actuary of events, including those that would be relevant to contracting out. Again, that's in our skeleton. Under guidance note 28, the actuary was required to reconsider whether the reference scheme test continued to be satisfied whenever told about a change which might affect the scheme's ability to satisfy the test. So if I could ask you to turn to guidance note 28 in tab 43. It's page 1103.
This is GN 28, yes.
GN 28, as at 17th of March 1997, the data on which the miscellaneous amendments regs came into force. 2.5. The actuary must reconsider the scheme's ability to meet the statutory standard whenever informed, in accordance with guidance note 29, all regulations made under section 47, subsection 9, or section 37 of the Pension Schemes Act 1993, of a change which might affect the scheme's ability to satisfy the test, and in carrying out such reconsideration must comply with part 5. So there were 3 triggers. And we'll come back to section 5, I assure you, but first can we note paragraph 2.4, setting out the third and very significant mechanism which we've touched upon, namely full recertification every 3 years. While the level of accrual demanded by the reference scheme test was extremely low, if exceptionally a rule change since the last certificate had jeopardised satisfaction of the test, the actuary was professionally obligated to say so and the rules could be corrected. But as a fourth mechanism, the ultimate deterrent sanction if the reference scheme test was not met was cancellation of the contracting out certificate, with national insurance contributions becoming payable at the full rate from the date as at which the certificate was cancelled. And to make that good, can I ask you to...
Do you mind, I'm sorry, before we go away from 1103, I'm just making sure that I've understood what the process here is. There's a sequence of steps under 2.1 through to 2.5, which you took us to. So we start off with the original certificate, which is the one that couldn't be found in this case, being provided.
Well, the original certificate was found, my lord. The issue here is that there were we've got all of the triennial certificates to show that.
No, I'm looking at 2.1 here, which is.
We have the original certificate in this case from 1998, I think, and then there was another one produced in 2001. So we have all of the certificates. There's no question that this scheme ever, in fact, went below the reference scheme test. It's clear that it did satisfy the reference scheme test. That's part of the...
Right, I'm sorry, no doubt I'm behind everyone else on this, but could you just fit paragraph 2, which you've just taken us to, into the scheme of events of this case, in order to explain your submission again on sub-paragraph 5.
My submission on 2.5 is that there were the protections of contracting out were not exclusively confined to section 37 of Reg 42. There were obligations on the actuary to reconsider whether the reference scheme test was met whenever the actuary heard about changes.
When you say that the reference scheme test was met, you don't just mean the reference scheme test is met for benefits which at that date are past service, you mean will continue to be met for future service benefits. When GN28 says the actuary must reconsider the scheme's ability to meet the statutory standard whenever informed
Yes.
of a change which might affect the scheme's ability to satisfy
For
the
both.
test, that must mean not just that the past service rights have been calculated in such a way as to meet the statutory standard, but that the benefits which will continue to accrue under the changed terms of the scheme will meet the statutory standard, must it not?
Well, the ability to satisfy the standard, I agree, has to be considered both forward and back. That I accept. What I don't accept is that being informed, and the reference to section 37, necessarily, if you like, means that section 37 is concerned with being informed.
This can't tell you what section 37 means, but it can tell you what the actuarial body that was responsible for GN28 envisaged would happen, which is
Yes.
that when you got notification of the section 37 change, which you say is only past service rights, the actuary should consider whether it will continue to meet the test going forward.
No, that's not what I was accepting. What I was accepting is the actuary must reconsider the scheme's ability to meet the statutory standard whenever informed by either of these means of a change which might affect the scheme's ability to satisfy the test. So you're told of a past rule change, you look at its impact on past service rights, and you consider how it's going to affect the future. So you look at both. What I'm not accepting is that the reference to being informed in accordance with section 37, which on my case might include being told about a change that happened a year ago, tells you about the content of section 37 of Reg 42.
I'm not suggesting that it does. I think you have accepted. What I'm trying to ask you about, but I think you've accepted this, is that when it says the actuary must reconsider the scheme's ability to meet the statutory standard, and when it refers to a change which might affect the scheme's ability to satisfy the test, that is both forward-looking and past-looking.
Yes. My Lord Jackson was asking though.
I'm sorry, but I'm still slightly confused. Are you saying, nevertheless, that Section 37 is only looking backwards, accrued rights, and therefore, when you're looking at that as an actuary under paragraph 2.5, actually the reference, you may have had your consciousness tweaked by Section 37, but it's, and you check, but it's not going to deal with anything going forwards.
The reference, I think, is to regulations made under Section 37.
Okay.
So this is contemplating looking forward to Reg 42 itself. Section 37 doesn't really tell you what it's biting on.
No.
That's left to the regulations. My proposition is that, yes, whenever an actuary is told of changes which might be relevant, they need to look forward and back.
Okay.
But what I'm suggesting is that doesn't entail that the protections in Reg 42 are linked to both past and future service benefits.
So, just to be sure I've got this right, suppose you have a scheme which provides NTLs, which is what the statutory standard is, basically, and you have a change which reduces that to N100s for the future. You say that doesn't have to be given to the actuary under Regulation 37. But if the same change not only reduced it for the future to N100s, but reduced it for the past to N100s, it would have to be given to the actuary under Regulation 42. And at that point, the actuary would not only concern him or herself with the change to the past service, but also with the change to the future, and say this scheme is no longer going to satisfy the statutory standard.
No, my lord.
No, is that not what 2.5 says?
No.
I thought that's what you just accepted 2.5 said.
My proposition is that if told of a change for the future, the actuary that's going to affect the future, the actuary has to think about it anyway under the professional obligations to do so under Guidance Note 28.2.5. He's got to think about the future anyway.
That's what I was just asking.
Yeah. But if there was a change that was only affecting the future, the actuary would still have to be told about it under all the other protective provisions that we've identified. He has to be told about it. There's the undertaking that is given by the trustees in compliance with Guidance Note 29. There is the obligations under Section 47 to tell them about a future amendment. When told by any of those other ways, then the actuary has to consider whether that will work for the future. Right. But the reason there is a particular protection imposed for the past is because you could reduce those rights without infringing the contracting out requirements, provided that you reduce the benefits in the past to an acceptable level that still met the reference scheme test.
I see. At some point, you're going to explain why that wouldn't infringe Section 67.
Because
I'm thinking.
Because, well, I'm acutely conscious of the time, but because Section 67 was subject to at least 2 easements. The consent requirement that a member could agree to a rule alteration that reduced their accrued rights, right. and also the actuarial equivalence requirements, which could allow a benefit to be reshaped or remodelled, provided that its overall actuarial value was thought still to be the same. So in terms of contracting out requiring pension benefits and requiring them to be payable from particular ages, you needed to protect the contracting out accrual in accordance with the arrangement between the state and the scheme. And an employer could go to a member and say, look, here's 50 quid, consent to this. You could have a payment outside the scheme to procure consent to a change. And the state couldn't accept that as something that could be done for the purposes of contracting out. And if you look at Section 9, you ask, well, is that a coherent thing? Do we see that anywhere else as a sort of pattern? Yes, we do. If you look at Section 91, that prevents alienation of right, surrender, it is still subject expressly to Section 159 of the 1993 Act. So if you turn in the authorities bundle to Section 91, which is tab 3, page 140, you see at subsection 5, section 91, all of the ways in which you could alienate an accrued right. The reference to entitlements for accrued rights is up in subsection 1 at the beginning, but then you see under 5 that there could be a surrender at the option of the person in question for acquiring entitlement to further rights under the benefits under the scheme. You could have commutation. You could have charges, lien or set-offs enabling the employer to discharge monetary obligations due to him. There were a whole load of exceptions. And yet when you turn to subsection 7, this section is subject to section 159 of the Pension Schemes Act, inalienability of guaranteed minimum pensions and protected right payments. And when you turn back in tab 2b to section 159, which is at page 132, you have a different, additional, supplementary protection for contracted out rights.
That seems to apply to GMPs and protected rights. Is there something extending it to section 92B rights?
Not to that provision, no, my lord. But what it shows is that it is there are other places in which the legislation makes protections for accrued rights, whether in terms of their alienation, section 67 rule alterations, and yet there is a supplementary, additional protection imposed to protect contracted out rights. We say it's unsurprising and congruent that Regulation 42 is concerned to protect accrued rights and does so as a supplementary mechanism on top of Section 67 in just the same way that Section 159 does or Section 91. But I must move on with the mechanisms just to give you the framework. If you could turn in tab 2b, page 100, you have section 34, which provided for cancellation of certificates, providing by subsection 2 that the Secretary may enable, regulations may enable the Secretary of State to cancel certificates where he's been reason to suppose that the employment ought not to be treated as contracted out employment, and the employer does not show that it ought to be so treated. And Regulation 47 provides the relevant regulations. That's tab 6, page 227. So Reg 47 is on 227. And that threat of cancellation with national insurance certificates becoming payable at the full rate from the date as at which the certificate was cancelled was in practice no doubt sufficient in almost all cases to ensure that matters were put right. And as a fifth mechanism, within tab 2b, page 115, it's section 53, that gave the Secretary of State a wide-ranging power to direct the trustees and or employer to take such steps as might be specified, which could no doubt have included increasing benefits by any amount necessary to satisfy the reference scheme test. So if the actuary said, you made this amendment in the past and it was a year ago, I'm concerned that you're not satisfying the reference scheme test, there could be a conversation with the contributions agency. If the rights were not restored to the requisite level, the Secretary of State could cancel the certificate and say, you've got now to discharge, to secure rights at the requisite level under the power to make directions in section 53. And if for some reason the contracting out certificate was instead cancelled retrospectively, which we think was probably unheard of, Contributions Agency Manual CA 15, as they provided that the liability for full contributions arose from the day after the date with effect from which the certificate was cancelled. That's, for your note, tab 50, 1193. I won't take you to it, given the time. But no question of collecting contributions from employees would arise, because the Social Security Benefits Act 1992 imposed the obligation to pay contributions on the employer by deduction from earnings exclusively. So the only way in which employees could ever be made to pay was by deduction by the employer as they were as pay was earned. And that's A1, Authorities 1, page 15. You can see at paragraph, this is in Schedule 1 to the 1992 Act, Section 3, paragraph 3, sub 3. A secondary contributor, which is the employer, shall be entitled and subject to, in accordance with regulations, to recover from an earner the amount of any primary class 1 contributions, notwithstanding anything in any enactment, regulations under this subparagraph shall provide for recovery to be made by deduction from the earnings and for it not to be made in any other way. So if it revived, it was still only ever a liability of the employer who would have responsibility. Just completing this section as quickly as I can. If you turn back to Regulation 42 itself, which is tab 6, page 222, you see paragraph 3 provides that where the provisions of section 37 continue to apply after a scheme has ceased to be contracted out, this regulation shall continue to apply so long as the circumstances provided for in subsections 3 or 4 continue to apply. So this is necessarily looking at past service where there's no future accrual at all, and yet Regulation 42 is still has to be complied with. So it can't simply be future looking. And it can't be reasoned from the reference to continuing to satisfy the statutory standard that Regulation 42, paragraph 2 necessarily protected future accrual, because you had to do that even after future accrual had ended. So with that introduction, if we go back to guidance note 28, tab 43, page 1106, we've got ongoing supervision under paragraph 5.1. Whenever the actuary is informed of any significant changes to the membership, including remuneration patterns, or to the terms of the scheme, consideration should be given as to whether such changes would adversely affect the ability of the scheme to pass the test of equivalence. In such circumstances, the actuary should be satisfied that it would have been possible to certify pass conditional, that the scheme satisfied the test of equivalence immediately following the relevant change. In other words, at the past date from which past accrual is adversely affected. And if not, the contributions agency, the employer and the trustees should be notified unless the situation has been rectified before notification takes place. So on learning of the past alteration, the actuary could run the reference scheme test prospectively from the effective date of the alteration in the past. Now, if a past change to the terms of the rules was having to be considered by the actuary for the first time after the event in this way, on the judge's interpretation, it was already void and a nullity. And there was nothing to notify the contributions agency about, and nothing to rectify, because it was a nullity, it was void. But this makes perfect sense on our interpretation. While a past alteration affecting past service accrual might be void, a past alteration affecting accrual which was only future accrual at the date of the alteration was valid and could be assessed against the reference scheme test and rectified if problematic, with the contributions agency being told if it wasn't rectified. Now, the learned judge said that she didn't know what terms meant, but that it couldn't mean rules. With respect, we disagree. The terms of a scheme are what it says in its rules. Now, admittedly, paragraph 5.2 then added, before a proposed change in the rules of the scheme can be made, Regulation 42 requires the actuary to notify the trustees in writing that the scheme will continue to satisfy the statutory standard after the alteration is made. But that's a manifestly incomplete and inexact summary of Regulation 42, which on its face would require confirmation of absolutely all rule amendments, even those with no bearing on benefits, which is obviously not intended. The Institute of Actuaries has omitted any reference to the nature of the rights to which Regulation 42 is restricted. And as Lord Hodge told us in Crown and the Home Secretary, such external materials can't trump the express terms of the definition, Section 9.2b rights, within the legislation itself. And such guidance is normally considered a relatively weak aid to the interpretation of legislation anyway. So, as I say, on our analysis, Regulation 42 is a congruent supplement to Section 67, just as Section 159 is a supplement to Section 91.
Do you accept that in 5.2 of GN 28, when it says the actuary must be satisfied, notify the trustees that the scheme will continue to satisfy the statutory standard after the alteration is made? But on the face of it, that, just like 2.5, is dealing with both past service and future service.
I don't. Because I've showed you Regulation 42, subparagraph 3, which says this all has to be complied with, even if it's no longer contracted out, even if it's all past, you still have to satisfy this.
Well, obviously in a scheme which has no future service rights, it's only referring to past service rights, but I don't see how that assists in deciding what it means when you do have past and future service rights.
because it means that references to continue to satisfy the statutory standard are not necessarily forward-looking.
Not necessarily forward-looking.
No.
The question is, could they include forward-looking?
Well, they could.
You accepted at 2.5 when the actuary is told you have to reconsider the scheme's ability to meet the statutory standard. That's both forward-looking and backward-looking. And I'm just asking you whether you accept that in 5.2 the same words will continue to satisfy the statutory standard. There's also forward-looking and backward-looking as a matter of just sort of reading GM28. And you say no.
I'm saying it could have that meaning. References to continue to satisfy the statutory standard are clearly being used in both for the past and for the future in Regulation 42. It's clear from, for example, subparagraph 3 that it's meaningful to talk of continue to satisfy the statutory standard in respect of past rights. So I'm saying what my proposition is, while I accept that the words continue to satisfy the standard could include both future and past, when you go to look at Regulation 42 itself, which is the governing provision, it refers to Section 92B rights. Section 92B rights tells you what is being protected. And the fact that this is a manifestly incomplete
Yes.
thing.
Now, where have we reached?
I have, I'm running out of time. If we are to rise at 4:15.
You've run out of time.
I have run out of time. If the court is content to sit until 4:30, then I can complete my submission.
No, it isn't content to 4:30. Can you finish your submissions by midday?
I can.
Right, and the balance will come out of any time for reply if necessary.
Understood, my lord.
Right.
On our case, the result is a two-strand approach to rule alterations. The draconian remedy of rendering alterations void, if not approved by the actuary, is reserved for alterations that affect benefits from past service, which warrant a high degree of protection, consistent with Section 67. Alterations to future benefits are not voided, but will lead to loss of contracted out status if the divergence is not remedied pursuant to the wider regime, both triennial recertification, obligations on the actuary, etc. And we say that's an entirely rational policy basis for legislation. And we say there's another good reason for that. If changes to benefits accrued before the alteration were permitted to stand, but those changes would have caused the scheme to fail a reference scheme test, Regulation 47 only permitted the contracting out certificate to be cancelled from the date on which the scheme ceased to satisfy the reference scheme test. So you could only cancel and go back as far as the date of your rule alteration. If changes to benefits accrued before that date were permitted to stand, the employer might retain the advantage of reduced national insurance contributions for service which didn't deliver benefits sufficient from contracting out. That problem doesn't arise for future service accruing after the date of alteration. The contracting out certificate could be cancelled retrospectively back to the date of alteration. By contrast, the judge's reading leads to consequences, we say, wholly disproportionate to the problem. A failure to get actuarial confirmation for an alteration in relation to future accrual would cause the alteration to be wholly void, regardless of whether there would have been any issue with the actuary giving such confirmation, because the reference scheme test requiring only such a low level of accrual continued to be met and would be reconsidered triennially and the subject of the actuary's obligations anyway. It produces indiscriminate voidness regardless of mischief. Now, can I ask you to turn to tab 57 in the authorities bundle. Page 1260. And you see there section on detriment to property rights and economic interests. It's a principle of legal policy that the property and other economic interests of a person should be respected and therefore that as an aspect of the principle against doubtful penalisation, such interests of a person should not be interfered with, particularly without adequate compensation, except under clear authority of law. An act should not therefore be construed so as to interfere with or prejudice established private rights on the contract or the title to property unless it's clearly intended to do so.
This is Halsbury.
That's Halsbury's. You can see that at the beginning of the tab. Now, before Regulation 42, employers and trustees had rights and liberties under amendment powers in their deeds and rules to make alterations to future accrual. Members had no right to stop them. Of course, employers and trustees could have their rights to make alterations to future accrual circumscribed substantively or procedurally by clear law. But that would be an interference with their existing private rights. And if you turn to tab 61, which is in the supplementary bundle, page 1342, it is a principle of legal policy that a person should not be penalised except under clear law, or in other words, should not be in peril upon an ambiguity. So the court, when considering in relation to the facts of the instant case which of the opposing constructions of the enactment would give effect to the legislative intention, should presume that the legislator intended to observe this principle. It should therefore strive to avoid adopting a construction which subjects a person to any detriment where the legislator's intention to do so is doubtful, or penalises a person in a way which was not made clear by the legislation in question. And in footnote 2, it's explained that this principle against doubtful penalisation, whenever it can be argued that an enactment has a meaning requiring infliction of a detriment of any kind, the principle comes into play.
Well, all this works if only your client's interests were at stake. But there are other interests to be considered here, not just your client's economic interest.
With respect, no.
Right, you're the only people who have property in this, is that it?
We have rights under an existing trust deed and rules to make amendments, and not to be required under a balance of contribution power to pay money into the scheme to fund liabilities that are created within it.
Right, okay, that's the argument.
That's the argument.
Right.
And if you, mindful of my lord, your conclusions in the British Airways case about the employer having the right to determine the structure of benefits under a pension scheme.
Yes, I'm just wondering whether these issues about penalisation, which I haven't previously encountered in this context, are really this generalisation transfers over to this type of situation, where you may, in a sense, you may have the black letter rights, but your pensioners have legitimate expectations and they have a seat at the table.
But my lord, I see that you carefully didn't say they have rights. You said they had legitimate expectations.
Well, I've been listening for the past day and a half.
I apologise, my lord.
But I see how the point stands. But I mean, apart from you saying that this is a doubtful penalty, is there any more that can be said about it in the 5 minutes remaining?
If that. No, it's not a recondite or technical point, my lord. I accept. Even if you decided that you didn't want to apply the principle of doubtful penalisation, my point would still stand. That it's no answer to say all the trustees had to do was to get actuarial confirmation in writing procedurally, as you said at the beginning, my lord. Because the whole point, it wasn't clear from the terms of the regulations that they ever needed to. On any basis, we say there wasn't clear law requiring them to do so, and it will be employers and now the Pension Protection Fund who will pick up the bill for trustees and actuaries not doing so. And on any basis, the consultation materials which we've set out, together with the amendments made in 2013, show that our past service only interpretation was, at the very least, an available one. You've got the government's 2012 statements that the definition of section 9.2b rights within the regulations refers to accrued rights set in terms. You've got the explanatory memorandum saying that pensions industry representatives have informed the department that there was confusion about how the relevant legislation should be applied, and saying the intention of the existing legislation is to protect accrued rights where schemes wish to alter their rules, so that those rights, accrued while the scheme met the standards set out in legislation, are not reduced. And that commentary is borne out by the consternation expressed by the industry in response to the judgment below, including, for example, pension age, quoting a suggestion that the judgment overturned a 25-year consensus. Now, even if you for one moment thought that a purposive interpretation pointed in the direction of the judge's future service included interpretation as an available one, we say our narrower interpretation should nonetheless be preferred, because the court is entitled to have regard to the wider regulatory regime which supervise contracting out, and the proposition that in fact that has worked, and there is no remedial purpose that necessitates giving the wider reading to the definition of section 9.2b rights. There's no suggestion that there are pension schemes out there which fail to satisfy the test and deliver benefits because of these various other mechanisms. There is in practice no need for Regulation 42.2 to be given the judge's interpretation to achieve any remedial purpose.
Can I just ask a question which has been bothering me? You've explained this morning how, even outside Regulation 42, it's the duty of trustees to tell actuaries when they amend the scheme. And it's the duty under GN 28 2.5 for actuaries, when they're told, to have a look and see whether the statutory test will still be met, both for the past and the future. So how difficult is it to go through the communications with the actuary and say, here's an amendment, and the actuary writes back and says, that's fine. I mean, that's all you need, isn't it?
My lord, I agree if you appreciate that you need to give a confirmation in writing satisfying the requirement. What is clear, and was clear in this case itself, but ultimately irrelevant to the interpretation of the what was clear is the actuaries were always intimately involved with rule alterations. They were normally the ones that recommended them. The point was, because of the definition of section 9.2b rights,
They didn't say anything.
they didn't produce a written confirmation, seemingly, because they didn't universally consider that was required by the definition of section 9.2b.
So that's the problem. It's not the problem that people are routinely just ignoring their actuaries and going off and merrily
On the
amending
contrary.
the schemes, which would seem very bizarre.
Yeah, on the contrary.
It's that the actuary doesn't bother to put something in writing.
Well, my lord, that's not a fair characterisation.
Okay, the actuary chooses not to put something in writing.
It's-
doesn't
it's-
appreciate as obliged to put anything in writing.
It's that the words actually used in the definition of section 9.2b rights in the regulations use technical terminology which specifically relates to accrued rights. And in my submission, defensively, actuaries thought, well, I should look to the future and reassure people that this will be fine, and I'll recertify triennially in due course, and I will do it. It's all fine. I can tell them orally. But the obligation to go through the hoops, the rigid mechanisms of Reg 42, required you to look at what a 9.2b writes and decide whether you had to. And they didn't do so. And to say now, years after the event, for long historic accrual, where there is no problem, actually there's a purposive interpretation which I think would be a better fit. And the Jepson case, which I don't have time to take you to, talks extensively. There's a very helpful section talking about would purposive interpretations, you might have had a better way of doing it. It doesn't matter. You have to look at what the legislation requires.
Thank you.
Unless I can help you further.
Thank you, Mr. Strawberry. Yes. Mr. Short.
The move from guaranteed minimum pension to GMP rights governed by section 9(2)(b fundamentally altered the contracting out regime. The benefits to be provided in return for lower national insurance contributions ceased to be tightly prescribed by legislation, and instead schemes, by which I mean usually the employer acting with the consent of the trustee or vice versa, the schemes were able to design their own benefit packages, but only if those benefits were of a sufficient standard to replace the lost state benefits. And that was necessary both to protect employees, but also to protect the public purse. And so it reduced the risk that people would fall back on the state later on. Now, this new flexibility required a quite different approach to ensuring the benefits were of a sufficient standard. And that different approach involved the application of the reference scheme test by the scheme actuary. Now, this was encapsulated in section 12A, and in particular 12A subsection 6, and I'll come back to that in detail. But that's the provision that said scheme benefits were of a sufficient standard if and only if the scheme actuary had so certified. If and only if, emphatic words. Because the new legislative regime could have used an objective approach in which the question was if the benefits meet or exceed that standard or not. But it didn't choose that approach, and it placed responsibility directly on the scheme actuary. So if the scheme actuary said the test was met, then it was met. And that couldn't be challenged, save in extraordinary circumstances you can challenge a certificate. It couldn't be challenged just because another actuary would have disagreed or taken a different view. But similarly, if the scheme actuary hadn't certified that the benefits met the test, they didn't meet the test. And that's even if it was absolutely obvious to everyone that they would meet the test. So if you had benefits that were 60th accruals, where the whole of earnings, not just 90% over the lower earnings limit, were taken into account, where anyone would have, without any actuarial knowledge, would have said that's better than the test, you still didn't satisfy the test until the actuary had certified those benefits. It may not take the actuary very long, but it was a necessary step, and until that was done, the benefits did not meet the test. And so that had to be done, that confer certification from the actuary had to be obtained as one of the steps to ensure benefits were of a sufficient standard as part of the quid pro quo for the increased flexibility. There was also a change, my learned friend has referred to this, in that responsibility was to be placed primarily on the scheme actuary rather than on the occupational pensions board, something that had resulted in lengthy delays as everything was funneled through a particular office. Now that responsibility on the shoulders of the scheme actuary had to be exercised throughout the life of the scheme. So it had to be exercised at the outset, before or when the initial application election was made. That election had to include confirmation from the actuary that the benefits would meet the test. That's in Regulation 6.3, which is a tab 6, page 209, but that's what it says. I don't propose to go to it. But when that was done, when that confirmation was provided, it would be provided by the use of a prospective test under GN28, which was going to look at the likely accrual over the next 3 years. And I'll come back to the importance of the prospective test in GN28 in due course. There were also requirements for triennial recertification, again using a prospective test. And again, I'll come back to what that means here in due course. But the question for this appeal in my submission is whether a new package of benefits could be introduced between triennial recertifications or after the scheme has contracted out but before the first triennial recertification. Whether a new package of benefits could be introduced for future service that did not satisfy or was the lowest was not to be treated as satisfying the statutory standard, or whether that new package of benefits would be subject to Regulation 42. And it's our submission that the introduction of a new package of benefits for future service was subject to Regulation 42. That produces a straightforward and sensible regime consistent with the purpose of ensuring benefits are of a sufficient standard. And it could not be more simple. If a new package of benefits is proposed, the trustee has to tell the scheme actuary, or they can't introduce the new package. The scheme actuary considers the new package, and then if he or she confirms in writing that the scheme will continue to be the standard, the changes will be made. If the scheme actuary doesn't confirm in writing, the trustee and the employer have to say, come on, you need to tell us. But if the scheme actuary says no, these benefits are not sufficient going forward, then we say it's up to the employer and the trustees can either decide to modify the proposals and try again, or things stay as they are. But the consequence of my learned friend solution is that even if the scheme actuary says, no, these are no good for the future, the test will not be met for the future, Regulation 42 would still permit those changes to be made. And we say that's unlikely to be the correct approach.
But I think he says that if the change only affects the future, you don't even need to tell the actuary on Regulation 42.
That's right, yes. But that's one example. You can shoot first, ask questions later. Or, even if you do ask, you're told, no, this is no good, you can say, oh well, and go ahead anyway. That's just unlikely. But an inevitable consequence of his approach is that it permits the introduction of a package of benefits that will necessarily not meet the if and only if requirement of section 12A. So necessarily at the point of introduction, the benefit package won't satisfy the statutory standard. And that was the cannot be the intended effect. Now, in fact, the package may never be considered against the reference scheme test on my learning friends approach, because if it hasn't been brought to the attention of the scheme actuary in advance, and if it's then amended again before the triennial review, there will be no obligation on the actuary, or no circumstances in which the actuary will be called upon to look at that short period of accrual. It may be that an employer will say we have very difficult
economic times ahead, so I'm going to reduce benefits for the next 2 years. And if they go down, but they come up again by the time of the triennial review, the scheme actuary only has to carry out a forward-looking analysis at that stage. And it leaves an inevitable gap in the safeguarding regime. But even if it is...
So the actuary only looks forwards, he doesn't look forward and back at that stage?
That's the thing that the actuary has to do. It's different if he's told about the changes, but Regulation 42, one of the things it deals with is where the actuary isn't told of the changes. But
where do we find the obligation on the actuary to look forward when recertifying?
It's in GN28 because it looks at whether what benefits are expected to accrue over the next 3 years. But even if the actuary is told retrospectively or finds out or carries out the investigation, there is an additional and inevitable problem of unwinding the changes. So the company might have become insolvent, decisions have been taken, and it's obviously sensible to deal with this prospectively rather than try and unwind changes after the event. In my submission, the appellant's approach is based on giving an unduly narrow meaning to the term of section 92B rights as used in Regulation 42. And it is, in my submission, important to remember that it's Regulation 42 that's being construed rather than the definition as a standalone in Regulation 1(2). And it's the fact that one is construing Regulation 42 is lost with respect, in my submission, in the appellant's analysis, which depends over much on analysing particular words in the definition, in the abstract, and then transposing them into Regulation 42 without any real regard to its context or purpose. And given that context and purpose, in my submission, the term section 92B rights is apt to cover both past service benefits and future service benefits. It's not obvious why Regulation 42(2) should be limited to past service benefits. Only they already had a lot of protection, not complete protection, because in particular there would have been the possibility of amending them with consent. And one thing that's very clear is employee consent is not a good enough reason for the reference scheme test not to be applied, because it is a multi-partite agreement where everyone, including the state, has an interest in benefits being kept at the right level. But the fact that there is a good reason to protect past service benefit doesn't provide a good reason for excluding future service benefits from the scope of that regulation. And in my submission, it's unlikely that legislation was intended to deal really only with consensual amendments to past service benefits, but to leave future service benefits entirely unprotected. My learned friend took the court to some of the cases on statutory construction. They are well known to the court. I'm not proposing, unless it will be helpful, to go back to those cases. Two things are clear. The task involves ascertaining the meaning of the words used in the light of their context and purpose. And secondly, although the words used in the statute have a primary role, explanatory notes, consultation papers and other matters may assist, in particular in identifying the statutory purpose. So, unless it will be helpful for me to go to the case law in more detail, I'll simply deal with the legislation. what I propose to do is to deal with a couple of the consultation documents, then deal with the Pension Schemes Act, and then the contracting out regulations, although veer off at a tangent occasionally. The white paper gives a very modest indication of the importance of ensuring benefits under the new scheme, or the new regime rather, met the appropriate test for whatever that was going to be. And this is security, equality and choice. Tab 38, page 941, bundle. So he doesn't take things very far. Paragraph 2.9 refers to the quality test of salary-related schemes. In future, schemes will not have to guarantee each individual will receive benefits at least equal to CERTs, the abolition effectively of future GP rule. Instead, salary-related schemes will have to satisfy a more general test of overall quality, will be based on requisite benefits defined in legislation, will mean the value of overall future benefits offered by schemes should be superior to those offered in service. More detail can be found in the consultation paper behind the next tab, and that's tab 39. And this is, as is made clear in the introduction, was one of a series of technical papers on contracting out prepared in a focused consultation exercise with key representatives of the pensions industry. And this particular paper dealt with the new scheme-based contracting out test.
Prepared by the DSS, was it?
DSS or DHSS, possibly.
Well, there's a reference in paragraph 2 to an address for responses, which is DSS.
My Lord, I'm grateful, yes. I see that now, yes.
Do we have a date of it?
We have the date for responses, which is the 30th of June 1995.
At the back on page 986, it's May 1995, it says. The bottom.
Thank you.
And to be clear, this is consultation on the pensions bill, what was to become Pensions Act 1995. So it's not consultation on the regulation, it's not consultation on Regulation 42, but...
Well, it does say at the top, the Pensions Bill's secondary legislation. So,
yes,
is it not consultation on regulations which are going to be needed to supplement the bill?
yes. Right, yes. That's right, although I don't think they weren't ready, and what's said is still very much focused on the primary legislation rather than, for example, drafts of what was to become contracting out regulations. And it's paragraph 20 in particular that I rely upon, which is at page 983. And it may be, if I simply ask them to read paragraph 20, there is a reference there to in 1984 contracting out regulations, but what's being considered is whether a power was going to be exercised under section 37 or under 12A of the new Act.
Yes.
only takes one so far, but in my submission it's helpful to know that there was no suggestion in the consultation process that it would be possible to introduce a new package of benefits that hadn't been considered and found by the actuaries to satisfy the reference scheme test. Now, I'm going to turn now to the Act, and this is at tab 2B, at page 84. Is where 15 section 9. And taking it in stages, section 9, subsection 1, subject to subsection 4, an occupational pension scheme can be contracted out in relation to an earner's employment only if it satisfies subsection 2 or 3. And emphatic language such as only if, and only if appears throughout this legislative scheme. Subsection.
Contracting out is a continuous process. So
Yes.
that refers to contracted. It can start being contracted out or continue being contracted out.
Yes.
So,
And what was happening here was that the basis upon contracting out was changing. Not only was the basis of salary-related contracting out changing, it was possible also to contract out on money purchase basis. But it had been possible to contract out GMPs on a money purchase basis, but it's so complicated, I'm not sure one did. But in any event, this was the new regime. Subsection 2 says an occupation which deals with salary-related contracting out. Occupational pension scheme satisfies this subsection only if A, in relation to employer service before the principal appointed day, that's 6th of April 1997, it satisfies the conditions of subsection 2A, and B, in relation to any earned service on or after that date, it satisfies the conditions of subsection 2B. And so subsection 2B was intended to govern benefits earned from the 6th of April 1997 onwards. And inevitably, at this time, all of those benefits, anything that was going to be governed by section 9.2b, were future service benefits. And it would have been, and in my submission, was perfectly natural, perfectly ordinary use of language to say that the benefits that would accrue in the future were section 9.2b benefits. Subsection 2b, 2 capital B, then deals with the conditions that must be met going forward, and they start off by saying the conditions of this subsection are that the Secretary of State is satisfied that, and there are 4 things the Secretary of State must be satisfied with. Scheme complies with section 12A, that's the requisite standard of benefits, and we'll look at that in a moment. But pausing there, one can see how this works, because the scheme can only be contracted out if it satisfies subsection 9.2. Only satisfies 9.2 if it satisfies 9.2b in relation to April 97 service. Only satisfies subsection 9.2b if the Secretary of State is satisfied that the scheme complies with section 12A, provides sufficient benefits. It only satisfies section 12A if and only if the scheme actuary has so so certified. So an approach to Regulation 42 that allows a scheme to remain contracted out, even though a scheme actually hasn't considered the package of benefits that's being earned, doesn't fit with the primary legislation, which requires the Secretary of State to be satisfied that benefits do comply with the standard in section 12A. If one looks at it through the eyes of the Secretary of State, the Secretary of State can be satisfied that benefits are at the requisite level if the scheme actuary certifies benefits either at the start or in the triennial review, and if the Secretary of State knows that that package of benefits can only be changed if the scheme actuary again confirms the scheme remains offering benefits that meet that test. Whereas the Secretary of State simply couldn't be satisfied that the scheme meets the test if the benefits offered can be changed without going through the scheme actuary. So we say the structure of the primary legislation is entirely consistent with our construction of Regulation 42, but not with my own friends. Now going back to section 9 to capital B, the second condition is that restrictions imposed under section 40 of the Pensions Act 1995 apply to the scheme. These deal with employer-related investments and cap those investments at 5%, subject to some exceptions. So the scheme wasn't permitted to be contracted out if, for one reason or another, the employer-related investment rules under section 40 didn't apply to the scheme. I'm going to come back to that. And at C, the scheme had to satisfy certain other prescribed requirements, either in relation to resources of the scheme or could be broader than that. And then finally, D, the scheme doesn't fall within a prescribed class. And some of those other prescribed requirements are in the contracting out regulations, regulations 18 to 22, and they include some rules on lump sums, which I'll come to when I deal with regulations. Moving on to subsection 9.3, this is contracting out on a money purchase basis. Different approach is taken, which is much more of an objective approach. There's one reference to the Secretary of State being satisfied with something. But 9.3, occupational pension scheme satisfies this subsection only if the requirements imposed by or by virtue of sections 26 to 32, such other requirements may be prescribed, are satisfied in its case. And that will include, for example, the rules related to the calculation of the money purchase benefits referred to by Justice Nugee, and also some of the provisions on forfeiture, which I'll come to possibly this afternoon. At condition AA, the Secretary of State satisfied that the scheme doesn't fall in the prescribed class. And then finally, the rules of the scheme applying to protected rights are framed so as to comply with the relevant requirements and requirements in the statutory instruments. So that was the approach taken to money purchase schemes, contracted out money purchase schemes. But the essence is the money purchase scheme had to satisfy those requirements, so it couldn't be made contracted out. That's relevant when one looks at Regulation 42 to A. passing on briefly to section.
Looking at this provision, what is the role of the actuary certification in relation to the satisfaction of the Secretary of State?
The obligations for the actuary under section 12A don't apply to the money purchase scheme.
No, just looking at 9 generally. I mean, where it says that the Secretary of State is satisfied about something,
Yes.
is the Secretary of State likely to be satisfied about something without a certification by an actuary?
Well, no, the Secretary of State couldn't be satisfied.
Well, that was rather what lay behind
Yes.
my question, so that
And that
Oh.
fits in with Regulation 42 preventing changes that haven't been approved by the scheme actuary. Because if the scheme actuary has approved them, then they do satisfy the reference scheme test. The Secretary of State can be confident.
so a Secretary of State who was presented with something without an actuary certification wouldn't get anywhere.
That's right. Although in fact, the Secretary of State would not be able to treat the benefits as satisfying the test because they satisfy the test only if and only.
But so it's implicit in the way that the scheme works in your submission. That,
Yes,
that for the Secretary of State even to be able to get out of the blocks to consider a scheme, there would need to be an actuary certification.
My Lord, yes, but for salary-related schemes, not for the money purchase schemes. Money goes into an investment bucket. Protected rights are dealt with at section 10, and subjects of subsections 2 and 3. Protected rights of a member of a pension scheme are his right to money purchase benefits under the scheme. In my submission, that's not limited, or the expression protected rights is not limited to accrued rights. What was being done was a framework was being set up to allow benefits to be accrued in the future, necessarily future service rights at the date of the legislation. And pausing for a moment, if someone had asked, well, members are going to accrue rights from April 97 onwards. Someone had asked this in 1996. Members are going to accrue rights in 1997 or after. What are we going to call them? The answer would have been protected rights. No one would have said, well, we don't have anything to call them because protected rights is limited to what someone has already, and no one has any of these rights already. Because the word rights is broad enough in some cases to anticipate rights that you will accrue in the future. And where we're dealing with schemes, a regime being set up to allow those rights to accrue, it necessarily encompasses those future rights. And when this court was considering the meaning of rights in the BBC case in the context of section 91, was dealing with the surrender of rights, necessarily involving a focus on what existed at that time. But the word rights is used so often, so many different contexts. One has to look at the particular context to decide if it can refer to something you will accrue in the future. And here, primary legislation is designed to govern the structures under which rights will accrue in the future. And once they've accrued, how they are treated. But it's unhelpfully artificial in my submission to say it deals only with the past. Section 12A is on the bottom of page 86. This is the statutory standard. Subsection 1 says the scheme must satisfy the statutory language. 12A subsection 3 explains what that means. A scheme satisfies the statutory standard if the pensions provided for such persons are broadly equivalent to or better than the pensions which will be provided for such persons under the reference scheme. 4 and 5 provide for regulations to be made to assist in determining whether the pensions are broadly equivalent or not. And 5 is important because it allows or anticipates guidance being prepared by a prescribed body and approved by the Secretary of State. And that's why, and that's GN 28, which is approved by the Secretary of State. And I say it's part of the, it's not simply what the Board of Actuaries thought. It's approved by the Secretary of State. It's part of the overall statutory scheme that can be taken into account.
You said GN 28. Is it 28 or 29?
28. 29 is related. It does require, as my learned friend said, the actuary to obtain an undertaking from the trustee to tell them if there are any changes, but valuing the reference scheme test is GN 28. I nearly forgot. 12A6, which is really the essence of the case submission. The pensions to be provided for such persons under a scheme are to be treated as broadly equivalent to or better than pensions would be provided for such persons under a reference scheme if and only if an actuary so certifies. And that's the absolute heart of the regime, is to require the actuary to say whether the test is met or not. I've always referred to the scheme actuary. There is an exception, very limited prescribed circumstances where it needn't be the scheme actuary, really for very small schemes where you don't need a scheme actuary. But for all intents and purposes, it's the scheme actuary appointed under legislation. And that requirement in subsection 6 to section 12, and the statement that provision that benefits only meet the test if and only if they've been certified by the actuary is at the heart of the regime for ensuring benefits are as they are.
I'm sorry, I should easily by now know this, but can you just explain again what's the reference to the reference scheme?
The reference scheme is in section 12B.
I see.
And that is a pension that provides at least 1/80th accrual.
Right, so that's the benchmark.
It's the benchmark.
Right, but yeah, okay. So here we are in 1990. What is the date of this drafting? 12A6.
This is certainly in force from the 6th of April 1997.
Right, so we're putatively in 1996, where this legislation is under consideration in 1996, comes into effect in 1997.
It's passed in 95.
It's passed in 95.
Right, sorry.
But it was always envisaged
Yeah,
coming in force on the 6th of April 97.
Right, okay. 1995, we're in when we're looking at this subsection. And it's the pensions which would be provided that subsection is concerned with. Right, and your submission, as I understand it, is that covers all aspects of the pensions, of the pension scheme that is being considered for certification.
No, my submission is it covers all things that are governed by section 12B. So it's the pensions. It wouldn't cover, for example, long-term injury insurance as part of some pension schemes. It wouldn't cover death in service payments. But it's basically the pension.
The pension.
So an actuary may have a scheme that mirrors the reference scheme test, where there's 1/80th accrual and...
All right, I can follow the sort of examples you might give, but is your general point that when it's talking about the pensions and comparing it with the pensions which would be provided under the reference scheme, the pensions to be provided,
Yes.
that there is no warrant in the primary legislation for cutting that down to a consideration of past service?
My Lord, no, far from it. This is entirely focused in the future, requiring pension accrual to continue to be sufficient to meet the reference scheme test, which is applied on a prospective
But
basis.
you interpret that as being the pensions to be provided are pensions both in respect of past service and in respect of future service.
Yes, although at the time the Act was made, there was of course no past service that fell within section 92B. Because 92B is only for service from the 6th of April 1997 onwards. But it necessarily governed future service.
And you're saying that's the nature of the reference scheme also, inevitably.
Yes. As approached via GM. Now, it may be helpful to make just a few comments about the reference scheme test. My learned friend said it's not a particularly onerous test, it's accrual at 80th. But the most difficult part of it is earnings, because it took account of earnings, 90% of earnings above the lower earnings limit. And in the more difficult cases,
It was between the lower earnings and upper earnings.
that's right.
That's the slice of income which qualified for the state sector pension.
Yes.
Which this is the substitute for.
Yes. And so if a scheme said all earnings were taken into account on your 80th, you would be well above that. If it excluded, for example, bonuses or commission, depending on how the scheme was set up, you might be getting 80th, but of a lower figure. And so quite a lot of the attention of the Act and GM28 does refer to pay packages and pay arrangements, because it's not always very straightforward to say you will beat the test. But that difficulty usually won't be. But you can tell if a 60th is bigger than an 80th or smaller than 100, but the pensionable pay may be more difficult. Now, those are my submissions on the primary legislation. I'm going to go to the contracting out regulations, and it is, in my submission, convenient to start with those regulations in their original form. And these are at tab 5, page 160. And these are made in April 1996. And it's regulation 1.2. The words referred to as the STEM. But in these regulations, unless the context otherwise requires. Those words are retained after these regulations were amended in 1997. But what that STEM, unless the context otherwise requires, means is that even if the statutory definition come on to does have the narrow meaning suggested by my learned friend and cannot encompass future service benefits, it will have to give way if the context and purpose of the provision being considered otherwise requires or compels it. No material difference. So even if the words introduced in 97, pension repayment and accrued rights, do have a limited meaning, say if you just look at those words, ignore the context, they do have that limited meaning, but it doesn't follow that when the phrase section 92B rights is used in regulation 42, you import that narrow meaning into regulation 42.
Can I understand your submission about this particular regulation? You're right to approach it on the basis that your primary case rests on the definition of 92B rights alone.
Yes.
But your backup case refers to the preamble.
Oh, that's right. I say that in context, section 92B rights can be read sufficiently widely.
Right, because we have to interpret regulations in their context anyhow.
Yes. But in regulation 42, it has the broader meaning that would encompass future service benefits, either by reference to the words of the definition, and if not, fallback position is the context requires the different approach taken anyway. And that introductory phrase, unless the context otherwise requires, shouldn't be treated as simply boilerplate. It appears in these regulations, it appears in some of the other regulations, statutory provisions, but not in all of them. And it seems to have been a deliberate choice to include it in some places and not others. So, for example, and we needn't go to them, it's not in the protected rights transfer payments regulations 96, which are behind tab 7, and it's not in the contracting out transfer and transfer payments regulations 96, which are behind tab 8, and these are all, this is the suite of regulations that was amended at the same time. It is in the personal and occupational pension schemes protected rights regulations 96, which is behind tab 9, and it may be that where the regulations have a more general role, so the words are being used in a variety of contexts, one's much more likely to find that, unless the context otherwise requires provisions, than where the regulations serve a very narrow role, such as the ones that deal only with transfer payments. But moving down to the definition of section 92B rights that's found in the original version, it says there are section 92B rights, this is on page 161, are rights other than rights attributable to voluntary contributions, in the meaning of section 111 of the 93 Act, which are attributable to an earner's service on or after the principal appointed day, which is contracted out in accordance with section 92B of the 93 Act. And that, in my section, is pretty straightforward as including future service benefits. The difficulty with that provision wasn't that it simply referred to rights. From a temporal point of view, the temporal limitation is given by the reference to service on or after the principal appointed day. But the problem was with the scope of the rights, because this would, on its face, include death in service, long-term injury, when they weren't dealt with in the reference scheme test. And so that, in my submission, was the main effect of the amendments that were made in the 97 miscellaneous amendment regulations. It may be if I just deal with the amendment before lunch. The amendments were made in the Personal Occupational Pension Schemes miscellaneous amendments regulations 1997. They are at tab 11, page 282. And they're made on the 11th of March, day before Parliament on the 14th of March, coming into force on the 6th of April. And I say that's important because the Secretary of State approved GN28 at about this time. We don't know exactly when that was done, but we know that version 1.1 of GN28 came into effect on the 17th of March. And so it is an admissible part of the context that the Secretary of State approved GN28 more or less contemporaneously with making these regulations. The amended version is at page 284, but we'll look at that in the context of the contracting out regulations themselves. But I do refer to the explanatory notes. I'm only going to take you to these. Page 305. The explanatory notes. So the regulations amend a number of sets of regulations, Pensions Act No. 5. And then on the second page, all that's said in relation to this change is that it harmonises the definition of section 92B rights.
Sorry, where do you find that on 306? Oh, yes. Sorry, I've got it.
So the third bullet point down. And
Can I just ask you, we've got at tabs 7, 8 and 9 the other regulations where there's a similar definition of section 92B rights.
yes.
Is that after a similar amendment, or were they always in that form?
No, they were always in more or less the same form as in the original version of the contracting out regulations. This new definition
is put into all those
was put
regulations.
into all of them.
So can you unpack, maybe you've just done so, what's meant by harmonising the definitions?
Yeah, it's more or less the same. I think there may have been differences in relation to transfers in some of them, but they all use the basic expression of rights arising from pensionable service, and none of them included the reference to pensions in payment and accrued rights. So it did introduce a single new definition across the 4 sets of regulations, including the contracting out regulations.
While we're looking at the definition of section 92B rights, both as originally enacted and subsequently, it's apt to include not just the minimum you need to satisfy the statutory standard, the N80 average slice of income, but all your pension rights.
Yes.
Yes. So if you've got a much more generous scheme, N60 scheme, all your rights to pension are still. There isn't any equivalent as there is in GMPs. With GMP in excess of GMP, it's just your pension rights are 92B rights.
Yes, and that I think was very much part of the purpose, because it meant you didn't need to administer 2 pensions.
Well, it is one of the problems of GMP.
Yes, whereas this meant your pension had to satisfy the test, so it had to be as good as or better than the reference scheme test, but it was one pension and they were your Section 92B rights.
So you could, on either side's interpretation of Regulation 42, amend your past service Section 92B right down from 60ths to 80ths, as long as you still satisfied the statutory standard and satisfied Section 67.
Yes, yes. You could do that
But you,
prospectively and retrospectively.
but you would still have to go and get the certificate, the actual written confirmation. Thank you.
And you would need consent.
Yes,
in
for
order
Section
to do
67.
that. And you would also be subject to any scheme-based factor.
Yes.
Whether you can do that or not. I'm going to go on to the new definition, which is at page 205.
Would this be a good moment to break off?